The Honorable Justices of the Supreme Court of the State of Iowa, hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session. Am I on?
Test, test. There we go. Thank you, everyone. Please be seated. It's usually a little smoother when we take the bench, but we appreciate this opportunity to do our jobs on the road. This is court on the road. So without any further ado, looks to me like counsel are ready to begin their oral argument. We're here tonight for oral argument in the case of Halbur versus Stephen Larson. And I do want to say, no relation to me. If so, I would have recused. Anyway, we're ready for the appellant. And Mr. Higgins, it's my understanding that you're going to go first.
Your Honor, actually, I represent the Appellee, and so
Oh,
yeah.
my note says appellant. Then it's going to be Mr. Valencia. Thank you.
Thank you, Madam Chief Justice. May it please the court, counsel, good evening. Iowa's whistleblower protections provide an exception to the at-will employment doctrine, but the district court reasoning threatens to turn the exception into the rule for a public employee who happens to be supervised by a qualifying public official. A textual analysis shows that our legislature enacted the whistleblower laws to protect certain public employees who risk their job security when they reveal previously unknown facts that give rise to illegal conduct to someone in a position to expose or correct that conduct, not when they simply assert disagreement with their boss. In other scenarios, this court has recognized the common law claim of wrongful discharge to protect private employees who engage in similar whistleblowing, but aren't covered by the whistleblower laws. And this court does that because it deems it necessary to protect the public interest in whistleblowing. The district court here correctly declined to recognize the common law claim here for Mr. Halbur, because the court recognized that a new claim here was not necessary to protect the public interest in whistleblowing, because Iowa whistleblower laws cover Mr. Halbur. He would have been covered had he blown the whistle. But the district court incorrectly determined that Halbur's complaining to his supervisor about his supervisor's conduct constitutes protected whistleblowing. So turning...
Counsel, I think the thing that bothers me the most is that it seems like it's one or the other. It seems like either you're covered by the statute or and then you won't have the common law claim, or you're not covered by the statute, and then you'd have the common law claim. And I struggle a little bit with how you thread the needle.
Your Honor, it's not here that it's either or. It's that even if you're covered by the whistleblower protections, you still have to follow the proper steps. And here, Mr. Halbur could have disclosed information that evidenced a violation of law to the proper person. But if we look at the statute, disclosure, the fair meaning of disclosure is revealing new facts. And you can't reveal new facts to somebody who did those facts.
Well, what if you had a fact pattern where the disclosure was to a supervisor, but it was framed this way: I've learned you're doing X, and if you don't fix it, I'm going to report you to the authorities. Would that be covered?
It could be covered if the supervisor then terminated that person. Because if you look at 70A28 subsection 1, we're dealing with subsection 2 here. Subsection 1 says that, and I'm going to shorten the statute because it's quite long, but a person who serves in a supervisory public official role shall not prohibit an employee from disclosing any information to a public official. And so that would fall, Justice McDonald, that's where yours would fall under. So,
But counsel, doesn't subsection 5 just provide a civil cause of action for a violation of subsection 2?
that's correct. But there's still a statutory remedy here, both under subsection 1 and under 8A. 8A 415, you can appeal the termination. There are statutory remedies here. And so the key part here is not just that you can't disclose the rule is not you can't disclose to a supervisor. It's a supervisor about that supervisor's conduct, because that's the fair and ordinary meaning of disclosure. And that's not just me saying that. That's how federal law interpreted disclosure. That's how many states interpret it. The federal Congress, after the Federal Circuit said that's how disclosure is properly interpreted.
Well, counsel, why isn't disclosure, I am disclosing that I know this fact? Why can't that be it? In other words, you may not know that I know about your misconduct.
Because it's a disclosure of information that evidences a violation of law. So disclosing that is just, I know that you're violating the law, but I'm not disclosing new facts, I'm not revealing new facts to you that evidences a violation of the law. Here it's just a disclosure of that I know you're violating the law, not information. And that's where information also does work here. That it's not just a disclosure of the fact of illegality, it's disclosure of information evidencing a violation of law.
Counsel, I know you didn't try this case, but could you address how error is preserved when this specific issue was not argued in a motion for directed verdict or JNOV?
This was preserved by arguing the motion to dismiss. It was fairly ruled upon, and trial counsel preserved it going forward by raising it in pretrial conferences, saying we still are disagreeing about this. If you look at the September 16, 2022 transcripts, pages 57 and 58, the district judge there referred to this decision as the law of the case and said that you don't need to do anything going forward to further preserve this. I grant you it's a bit of an odd situation, but this was preserved at the motion to dismiss stage. If you look at the Schooler case, 576 NW 2D 604, there it was similar where something was raised in the motion to dismiss stage, and this court said that even though it wasn't brought up again later on, the determination there was definitive and dispositive of the issue.
But wasn't the Schooler case about the district court's authority to proceed versus a substantive legal issue? Do you have a case where we've preserved a substantive legal argument by motion to dismiss after the jury trial?
I don't have a case in front of me that says that, but what I do know here is that counsel preserved this to the district judge, saying we're still objecting to this. Also, so in the jury instruction charge conference, same transcript, 9/16/22, pages 31 to 32, and the judge says you don't need to do anything further to preserve this. And so it was preserved in the motion to dismiss. It's a squarely legal issue here. We're not here challenging any facts. We're not here challenging any discretionary decisions. The issue here is simply whether
So let's assume that the error was preserved in the motion to dismiss. Does that mean then we are limited solely to the legal arguments presented in the motion to dismiss?
Yes, and the legal argument that we presented in the motion to dismiss was whether you can disclose to your supervisor about your supervisor. Those are quotes that we used in our reply on page 5 and in our motion to dismiss, appendix pages 32 to 33.
And then would we be applying the pleading standard, not kind of a quasi-summary judgment standard? We would just be looking at the face of the petition.
Yes, you would just be looking at the allegations in the complaint, but here, even the facts proven out at trial that we cited in our briefing, the trial transcripts, still cover the same things that were pleaded in the amended petition, which is that Larson knew about the buybacks situation as early as 2013. That's in the amended petition. It's also in the trial transcripts. And so when it was revealed to him that there were these buybacks that were over the statutory cap, that was known as early as 2013, he instructed there to be 3 more reports on it. He's the one that told Halbur to look into it. And then as for the BMI contract, Larson is alleged in the amended petition to be the one that, the one who entered into the contract. That's amended petition paragraph 17. And then at the trial, it was also proven out that he entered into it, drafted it. He's the one that executed it. So all of the facts, that knowledge Larson had before anything was revealed to him. So whether you look at the amended petition allegations or you look at what's proven at trial, we're not challenging the facts. It's squarely a legal question.
Let's say hypothetically we agreed with you that the statutory whistleblower claim shouldn't have gone to the jury. Doesn't that undermine the whole basis for the common law claim, as Justice May was suggesting? In that case, wouldn't we have to reinstate the common law claim and send the case back on that? Because then that we can no longer say the statute kind of covers the waterfront.
No, because it's not the case here that Halbur did not have a statutory remedy available to him. This court would only apply a common law claim if it was necessary because there is no statutory remedy available. That's what it does when there's private employees that aren't subject to the whistleblower laws. This court will imply a common law protection for that whistleblowing to further that public policy. Here, it's not necessary to imply such a cause of action because there was a statutory remedy. There was probably multiple under 8A and under 70A 28. It's just that they weren't used correctly. And just because you don't follow the steps that the legislature prescribed does not mean that you get a second bite at the apple to then get a common law claim that would effectively swallow the at-will employment doctrine itself.
On the common law claim, Halbur says that there are really two bases for it. One is the disclosure of information, and then the second is that he refused to engage in illegal conduct by signing the checks for the BMI, payment to BMI on this contract. So how do you respond to that second part about illegal conduct and distinguish Fitzgerald and Jasper?
Fitzgerald and Jasper deal with private employees, and so there wasn't the 70A 28 whistleblower protections. Here, the sort of the two ways that Halbur's trying to splice this is two sides of the same coin. It's saying, I'm not going to do that because it's illegal, and baked into that same statement is me telling you that I think it's illegal. And under 70A 28, if you look at the types of information that need to be disclosed, it's evidence of a violation of law, it's abuse of authority, it's mismanagement. Those are all things that if your supervisor is telling you you must do something that's illegal, that's an abuse of authority, that's mismanagement, that's information evidencing a violation of law. Those all fall within this statutory remedy. They just weren't, that statutory remedy was just not used here. And the practical consequence of implying a common law cause of action here is, I think, important to consider. If you apply a common law cause of action here, a common law wrongful discharge claim, what you'll be incentivizing is don't whistleblow, don't follow whistleblowing steps, stop short of it and say, I'm just refusing to engage in illegality. And that's because the 70A 28, the whistleblower statute, has a civil damages cap. So if you're a plaintiff and you want to get around the civil damages cap, you're going to stop short of actually taking the steps to disclose this illegality, which is what the legislature is trying to incentivize, to get these things exposed to the public so they can be corrected or modified. And you'll stop short of it and just refuse to engage in illegality and have no damages cap.
But do we really believe that Iowa citizens who are thinking about blowing the whistle on potentially illegal conduct sit down and study the Iowa whistleblower law before they do that?
I don't know that the average citizen would, but certainly if there's legal counsel, that's what I was saying, is pleading around. They might plead around it to try to get past it. The counsel might say, we're going to plead that we just refuse to engage in illegality, rather than saying that you tried to blow the whistle. And it's important, too, to know that the incentive is to get this conduct exposed. That's the public policy here. The public, the hard P's there. The public policy here is to make sure that illegal conduct that's going on in the Iowa government is exposed so that it can be corrected, modified, investigated. The public policy is not a follow the procurement contracts.
What about Halbur's argument that he did try to get exposure, but he tried to do it in an appropriate way by having Larson contact the state auditor and notify the Attorney General of these alleged illegal activities?
Right, so he's basically saying, I told Larson to whistleblow because I didn't want to whistleblow, and he's disclaimed any intent to actually whistleblow. Maybe in a situation where you go to your supervisor to disclose something that has to do with something other than your supervisor's alleged wrongdoing, and you say that could be one thing. But here, when you're going to your supervisor, the wrongdoer, and you're telling them to go whistleblow on the conduct they've been doing, that just totally belies the purpose of the Iowa whistleblower statute. And again, I do think it's important to look at how the statute's been interpreted in federal law and then also in the various states that borrow language from the federal law. this court does that, with the Iowa Civil Rights Act, where we adopted similar language to federal law. The Iowa whistleblower law did the same thing here. It took the same language, and so we should look to the federal precedent. And before 2012, which was when there was an important amendment in the federal Congress, the federal cases said this exact same thing.
Does it matter that Halbur also discloses information to other people in addition to Larson? So if I understand it right, he did copy Sutton, is that the right name? The COO, and then I can't remember the name, but the head of legal and compliance. So why aren't those protected disclosures for which Larson could have retaliated?
If those are people that fall within the statute of a public official, then perhaps that could be the case. That's not alleged here. What's only alleged here is that he told Larson in the pages 19, 26, and 36 of Halbur's brief. He says, I told Larson my opinion, only Larson, and he told him his opinion that these 2 buckets of conduct were illegal. There was no new conduct alleged, no new facts. He's just saying, I have this opinion that this is illegal. Larson knew all this conduct going on. He had been investigating this with the DAS director, with various reports, and there was no new facts. It was just him, Halbur, coming in with a new legal opinion. Legal conclusions are not facts, and this court deals with those in separate buckets regularly.
Mr. Higgins.
May it please the court, counsel. This is an appeal from a motion, a pre-answer motion to dismiss. And that is the case because the defendant at trial did not file a motion for a directed verdict, did not file a motion for judgment notwithstanding the verdict. And so what we are left with here is the pre-answer motion to dismiss. With this appeal, the defendant argues that the court should ignore the plain, unambiguous language of the Iowa whistleblower statute and create carve-outs that are inconsistent with both the language of the statute and the purpose of the statute. Todd Halbur likewise appeals because the district court erred in granting this defendant's motion to dismiss his public policy wrongful discharge claim against Stephen Larson. As it relates to the whistleblower statute, Iowa Code 78.28, this court has said in State v. Doe that if the plain language of the statute is unambiguous, this court applies the plain meaning of the statute.
Unambiguous. Whistleblowing, I think that term, you don't have to be a lawyer to probably get an idea of what it's about. But doesn't, according to the statute, it requires disclosure of something, and isn't it kind of common sense that disclosure refers to something, some kind of wrongdoing that maybe the audience, the person did not know otherwise, had been concealed? And we wouldn't have that in this case. So help me get around that.
Well, I would push back a little bit, Chief Justice, that we don't have that in this case. The facts as alleged in the petition should be taken as true. Again, this is a motion to dismiss. It's a disfavored motion. And the facts as alleged in the petition was that Todd Halbur made at least 2 instances of disclosures of information of illegality. One of which was the disclosure to his supervisor, Stephen Larson, who is a public official, in which he reported to Mr. Larson that Mr. Larson had entered into, that the contract that he had entered into was a no-bid illegal contract in violation of Iowa Code Chapter 8A, the competitive bidding law. And,
Okay, I get that, but he's tattling to the person that could get in trouble. I'm having a hard time with that. You said you called him a supervisor. It's the same guy, right? His supervisor is Mr. Larson.
The supervisor is the same guy. He is the...
Yeah.
Yes.
Yeah, so what did he disclose to Mr. Larson that Mr. Larson didn't already know?
He disclosed to Mr. I'm sorry.
Well, of course, maybe one person thinks it's legal, one person thinks it's not. But the facts, he didn't disclose anything he didn't already know, did he?
He disclosed to Mr. Larson that the BMI contract that Mr. Larson had written himself and entered into was illegal. As the comptroller was going to a public official and disclosing that the contract that Mr. Larson had entered into was illegal. And as the record developed in discovery, at the motion for summary judgment stage, and at trial, Mr. Larson denied that it was ever illegal or that he knew that or considered that before Mr. Halbur told him. Same thing with the markup, the illegal markups on liquor. Yes, it is true, and it is alleged in the petition that Mr. Larson had been made aware that the state was illegally marking up alcoholic liquor in violation of the cap. But that Mr. Larson, as it developed in discovery and at trial, he testified that it was his understanding, based on his conversation with the previous comptroller, that even though that they were above the statutory cap that capped the markup on liquor, it was not illegal. So when Mr. Halbur goes to Mr. Larson and tells him that what the policy is resulting in illegality, that was new. That was new information. And the best evidence that this was new information was this was the very first time that a change was made. And a change was made to the way that the liquor was marked up based on what Todd Halbur told him.
Isn't that kind of an indicator of what goes on in the workplace? If you're my boss and I tell you, hey, I think you should do it this way instead of that way, and I'm right, and you adjust your behavior accordingly, aren't we going to open up Pandora's box? Isn't that kind of how the relationship, the pecking order goes?
I think that is the way the relationship goes. But again, I would point you back to the plain language of the statute, which provides that if an employee makes a disclosure of information that the employee reasonably believes evidences illegality, mismanagement, or gross abuse of funds.
Look, can we talk about the plain language of the statute with respect to who the right person is? If you look at subsection 1 and the whole structure of 70A.28, the first subsection contemplates a disclosure being made to someone other than the person who is directed not to fire the whistleblower in sub 2. Would you agree with me that?
Well, I must admit I don't have the statute right in front of me, and that's a mistake, Your Honor. But my understanding of the statute is that it provides that a disclosure is protected.
Okay, but I'm talking about sub 1, not sub 2.
Oh, okay.
So the first subsection says, prohibits a person from requiring an employee to inform the person that the employee made a disclosure. So that would suggest that they're making a disclosure to someone else and you're telling him that you have to tell me if you do that. Or prohibits an employee of the state from disclosing certain information to the list of people. So again, the person in subsection 1 is being told you can't prohibit an employee from making a disclosure to a list of people who presumably would not include that person. Would you agree with that?
I agree with your reading of the first subsection.
Okay,
yes.
so, but shouldn't we read the whole statute together, and doesn't reading subsection 1 and subsection 2 suggest that the person in subsection 2 needs to be someone other than the person who does the firing?
I don't agree with that line. I think in the second subsection, what the legislature was concerned with was disclosures of information, so long as the disclosures are made to a delineated person, one of which was a public official. And so the purpose of the statute was to encourage employees to disclose information that they believed to be evidence of illegality or mismanagement to an appropriate person who can do something about it. And the legislature found that a public official was somebody who could do something about it. So that's the behavior.
Yeah, but I mean, even just reading 2, it says a person shall not discharge an employee for a disclosure of any information to, then there's a list, member of the General Assembly, public official, law enforcement agency, et cetera, et cetera. It really sounds like, if you read the structure as a whole, that person and then the disclosed, the parties receiving the disclosure have to be different. Am I missing something there?
Yeah, I don't read it that way. I read it as it precludes a person from terminating an employee for disclosing information to one of these identified people, one of which was a public official. So, you know, I wanted to comment.
Does the statute make a distinction between disclosing information and opinion? So, I mean, all Halbur really did was tell Larson things he already knew, with the additional fact that Halbur was of the opinion it was illegal. Is that a protected act?
I think it is, Your Honor. I think that one of the things that Todd Halbur had to establish in this case was that he had a good faith, reasonable belief that the information that he was disclosing evidenced illegality or mismanagement.
I'm sure you're ready for this, but maybe we talk about the parade of horribles and how this would actually work in practice. So the statute covers disclosures of mismanagement. So an employee goes to his supervisor, and anything he complains about that he thinks is evidence of mismanagement. So for example, if he came and said, you know, I really don't like this work from home policy. I think it's bad for morale and we're wasting resources. That's now a protected disclosure under the statute?
I don't think it would be, Your Honor. I think the statute has limitations that are built into it, right? So
What if he says, in my opinion, this evidence is gross mismanagement of human resources?
and the disclosure would have to be to one of the delineated people, which, assuming your fact pattern, if that was a public official, I believe that would be protected activity. Now, again, the legislature drafted this statute broadly to curb law breaking and mismanagement and abuse, gross abuse of funds. And so that's the way that it was written. But the employee in your scenario would have to show that he had good faith, reasonable belief that the evidence he was putting forward was evidence of illegality or mismanagement, and it has to be to a public official. And that employee under that scenario cannot be fired for raising that complaint. Importantly, in this case, we're not talking about mismanagement. We are talking about illegality, and we are talking about the comptroller of the Alcoholic Beverage Division going to a public official and disclosing 2 instances of illegality.
Counsel, the legislature chose to put a cap on the amount of damages available under the statute. Aren't we allowing lawyers and parties to evade that limitation if we recognize a common law retaliation claim?
I think that the common law retaliation, wrongful discharge claim is separate and distinct from the whistleblower claim. I believe that they protect different activities. The whistleblower claim is solely interested in the protection of disclosures. The public policy wrongful discharge claim, as recognized by this court on many occasions, can be supported, or you can have a claim if an employee is discharged for refusing to engage in illegality. So I think that the claims protect different activities.
So if you want to avoid the cap, if you want to avoid the cap, then the key is to just refrain from doing the activities and don't tell anyone.
Yeah, I hadn't thought about it in that strategic way, and to Your Honor's point, I'm not sure that would be something that a regular Iowan would think about. Again, I believe that the claims protect different activities. So if let's just assume Halbur had been directed by Stephen Larson, the administrator of the ABD, and said, sign these checks. And Halbur said nothing, but he refused to sign those checks, and he was fired for refusing to sign those checks. I believe that would be protected under a public policy wrongful discharge claim, but not under the state whistleblower statute. In this case, we had both types of protected activities.
So do you concede the common law claim ought to be limited to the act of refusing to participate in illegal activity and not include a disclosure to your own supervisor?
I do agree with that. To the extent the legislature has weighed in on that issue and provided a statutory remedy for a disclosure, that's right. There's no whistleblower claim at that point.
So at the time he refused to write the checks, there still was a valid contract there was a contract in place between ABD and BMI. So until that's set aside by somebody, a court or ABD, Why would it be illegal conduct to sign a check that the state was obligated to pay under its existing contractual relationship?
Well, I believe that the contract was illegal, and it would have been illegal for Todd Halbur to have.
That's true. That was his opinion, but it was still in place. No court had set it aside. They hadn't withdrawn from the contract. I guess I'm a little bit concerned about employees taking it into their own hands to decide when they are going to do or not do their statutory duties based on their legal opinion.
And I can understand that concern, and I agree with it, but that's not the facts of this case. The facts of this case was Todd Halbur told Stephen Larson that contract was illegal. It was an illegal no-bid contract in violation of Chapter 8A, and he refused to sign those checks as a result. And as a result of that, as the record developed, that contract was voided and not paid after the fact.
So is it your position that he had both a whistleblower claim and a common law claim?
I believe that Mr. Halbur was entitled to both claims. The whistleblower claims it relates to his disclosures of illegality, and the public policy wrongful discharge claim solely on the basis that he refused to sign those checks.
And so if we agree with you entirely, what's your remedy that you're asking for?
We would ask you to affirm the court's denial of the motion to dismiss the 78.28 whistleblower claim, and we would ask the court to reverse the district court decision denying the public policy wrongful discharge claim and send it back to the district court.
And what happens to the jury verdict?
We would ask the verdict as it relates to the public policy wrongful discharge claim to stand. And we would get an opportunity to try the case on the public policy wrongful discharge claim.
So does he have a public policy claim? Do both claims stand with respect to BMI? I thought you said that the BMI issue would go under the common law claim.
I'm sorry, Judge. I see them as being separate. I think that the sole issue for the public policy.
I just want to clarify. So under your position, the verdict should stand entirely, and then he still gets another common law claim with respect to BMI.
Yeah, with respect to the refusal to sign the checks to BMI, yes. And looks like I'm about out of time.
You are out of time.
I'm sorry. The clock's going the other way.
Grab a trouble here with our mics. You can summarize quickly.
Well, Your Honor, I think thank you very much for that. The only thing I wanted to wrap up was to just do essentially the prayer for relief, which I just went through here. So with that, I appreciate your time, and thank you very much.
Thank you. We have competing mics up here. Mr. Valencia.
I'd like to make 3 points, a little shorter than him. I'd like to make 3 points. First, on the preservation issue, counsel started with that, but they did not raise it in their brief. They, at no time raised it in their brief, they filed a motion to dismiss the event after briefing closed, and it was denied. They have conceded it, they waived it, and the error was preserved here. The second point, counsel agrees that we should look at the plain language of the statute. Counsel agrees that it's unambiguous, and in their brief they agreed that we should look to the Black's Law dictionary definition. That's at page 35 of their brief. And the Black's definition is what I've been quoting you, a revelation of new facts. And then counsel went on to talk about all of the facts that were already known.
Well, I think, counsel, isn't the definition something like that's hid?
Sorry, say that again?
I thought that the definition from Black's was information that is hid. The word hid is what strikes me. Not that it's new, but that it was hid.
The definition here is the act or process of making known something that was previously unknown, revelation of new facts. Hid could be in there as well. I only had part of what I suppose. This is the definition they quoted in their brief as well was the revelation of new facts was, and they're saying that they disclosed the fact of illegality. And so even if it hid is part of it, you can't disclose something that to the person who did it and, as if it was hid from them. They conceded the only thing they're disclosing is that it was illegal. The opinion that it was illegal. They're conceding that Larson knew in 2013 about the facts of the markups.
I want to turn to the public policy claim.
why is your opposing counsel wrong that we shouldn't sort of separate them? And looking specifically at that claim on the failure to sign checks or refusal to sign checks.
The underlying conduct is the same. It's an email saying, I'm not going to sign this check. And that's what they're pointing to say that they're disclosing illegality. And I think this court in Walsh v. Waller has said, if you have a statutory remedy under 70A.28, you don't also get a common law public policy claim because it is narrowly circumscribed and it's only implied when it's necessary to protect the public policy. So the public policy here is really the key point. What is the public policy they're pointing to that needs to be vindicated by a common law claim of wrongful discharge? And the public policy here is that they're trying to prevent employees from being fired for refusing to do something illegal, for refusing, for their supervisor telling them to do something illegal. That is mismanagement. That is an abuse of authority. That is information that evidences a violation of rule or law.
So your point of view would be that if they had reprimanded or otherwise taken negative action less than discharge in response to the refusal to do illegal action, then that could support a common law claim because that wouldn't be covered under the wrongful discharge statute.
Under the whistleblower statute? Right, because the whistleblower statute is a person shall not discharge an employee. I could see an argument for that hypothetical, though, under sub 1, that is trying to prohibit somebody from revealing information. I have not fully prepared for that question, but I could see it being under that, so I'm not ready to fully concede it, but it's at least not sub 2. And the other thing I would like to just point out too is back to the public policy point. The only public policy here that they point to is the public policy in the state's procurement laws and regulations. They're saying that is the clear, well-recognized public policy that must be vindicated by a common law wrongful discharge claim. That's in Chapter 8A. Chapter 8A also has administrative remedies available if you're terminated and that you can challenge your termination in 8A.415. That's in the same statute they're pointing to for public policy. In Walsh, this court said, if you're pointing to a statute that provides you a statutory remedy for your public policy argument, then you don't get to apply a common law claim here. And for all the reasons of the parade of horribles that this would lead to, if you imply a common law claim here, we ask that you affirm the district court's grant of the motion to dismiss on that claim and reverse the denial of the motion to dismiss on our 78-28 claim.
Thank you.
Thank you.
The case of Halbur versus Stephen Larson is hereby submitted.